Definitely, one question may be asked from this area. So, what are the sources of Indian Constitution? You know, Indian Constitution is a bundle of borrowings. Our Constitution Assembly members visited nearly 60 countries and they studied their constitutions and taken the suitable items which are suitable to our nation, our philosophical background, so that major concepts of our Indian Constitution are taken from some other constitution or taken from some other British Indian Act. In this video, we discuss about the sources of Indian Constitution. Before going into the details, we have to remember one thing. The Government of India Act 1935 has its own impact on Indian Constitution because more than 70% of items of the 1935 Act are directly inserted in Indian Constitution. So that 1935 Government of India Act is called as the blueprint of Indian Constitution and the Xerox copy of the Indian Constitution and the main source of the Indian Constitution. So let us discuss various sources of Indian Constitution. So here I am presenting you the world map. Here a few countries you have to remember: America, Canada, France, Ireland, Germany, Britain, Russia, South Africa, Japan and Australia. These countries are very, very important because their constitutions provide us many concepts. So let us see what are the sources of Indian Constitution from each and every country what we mentioned here. Coming to the first one, American Constitution. American Constitution has its own impact of our Indian Constitution. Many concepts were taken from that American Constitution. Here the concepts are not taken, not derived directly. Only the concept is only derived from such constitution. Coming to the USA Constitution, the concepts which we derived from the American Constitutions are preamble, concept of preamble. Here I mentioned American Constitution, preamble, constitution of preamble, fundamental rights, concept of written constitution, impeachment resolution of the president, impeachment resolution of the Indian president, P means president, removal of Supreme Court and High Court judges, independent judiciary system, judicial review, the concept of judicial review, the concept of public interest litigation, PIL, the concept of vice president. These are the concepts, major concepts derived from American Constitution. Concept of preamble, fundamental rights, written constitution, concept of written constitution, impeachment resolution of the president, removal of Supreme Court and High Court judges, independent judiciary system, judicial review, public interest litigation, office of vice presidents. These concepts are derived from American Constitution. And from Canada Constitution, we derived the concepts of advisory jurisdiction of Supreme Court, appointing governors, state governors by the central government, and residuary powers vested in central government, centrifugal form of central government means the strongest form of central government. These things are derived from Canada. Coming to the next one, South Africa, amendment procedure of Indian Constitution, election procedure of Rajya Sabha MPs. Coming to the Australia Constitution, we derived many things from Australia. Concurrent list, joint sitting session, as per Article number 108, joint sitting session, free trade and commerce. From Japan, next coming to the main one more country is Britain. From Britain, we derived many concepts: parliamentary form of government, cabinet system, rates, post of president, office of prime minister, Lok Sabha speaker and deputy speaker, all these things are derived from Britain. Next, coming to Russia, we derived fundamental duties and justice, which was mentioned in preamble. Coming to the Germany, suspension of fundamental rights during emergency. Next, Ireland, directive principles of state policy, election procedure of the president, nominating 12 members to the Rajya Sabha by president, election rights during emergency. Next, Ireland, directive principles of state policy, election procedure of the president, nominating 12 members to the Rajya Sabha by president, by president. France, the concept of republic, the concepts of freedom, equality, and fraternity. Next, Britain. Here I'm writing Britain already over. Like Japan, Article 21, right to live. Procedure established by law. Procedure to Japan. Next, Britain. Here I'm writing Britain already over. Like Japan, Article 21, right to live. Procedure established by law. Procedure established by law. And rule of law is derived from Britain. Next, Australia. Okay, these are the main sources we derived from other constitutions. From American Constitution, preamble, fundamental rights, written constitution, impeachment resolution of the president, removal of judges of Supreme Court and High Court, independent judicial system, judicial review, public interest litigation, PIL, and vice presidents. These concepts are derived from American Constitution. Canada, centrifugal form of central government means stronger central government, residuary powers vested in central government, appointing governors by central government, advisory jurisdiction of Supreme Court. These things are derived from Canadian Constitution. And Australia, concurrent list, joint shooting session, free trade and commerce. Japan, right to live, procedure established by law. South Africa, amendment procedure, election procedure. Next, election procedure of Rajya Sabha MPs. Coming to Britain, parliamentary form of government, cabinet system, writs, president, office of prime minister, speaker, deputy speaker, rule of law, and single citizenship. Next, coming to the form of government, cabinet system, writs, president, office of prime minister, speaker, deputy speaker, rule of law, and single citizenship. Next, coming to France, the concept of republic, the concepts of freedom, equality, and fraternity, and also electing a senior most person electing senior most person as a president to one committee. Ireland, directive principles of state policy, election procedure of the president, nominating 12 members to the Rajya Sabha by president. These three concepts are derived from Ireland Constitution. Germany, suspension of fundamental rights during emergency. And Japan, right to live and procedure established by law. And except these things, many things are derived from 1935 Act. 1935 Government of India Act. 1935 Government of India Act. Many concepts are derived from this. They are Office of Governor, and emergency provisions, President rule comes under emergency provisions, President rule, public service commissions, power distribution between state and center means emergency provisions President rule comes under emergency provisions. President rule, public service commissions, power distribution between state and center means here list 1, list 2 and list 3 means central list, state list and concurrent list. Such things are derived from 1935 Government of India Act. These are various sources of Indian Constitution. So there is a chance to ask one question from this topic. Fundamental duties is derived from USSR, and the concept of justice. Justice means social, political and economic justice. The concept of justice, the concept of fundamental duties are derived from USSR, now it is Russia. Okay, these are the various sources of Indian Constitution. So we are presenting you a mind map based on world map. I am pointing out from where we are taking the various concepts of Indian Constitution. Thank you. Salient features of Indian Constitution. In previous videos, we discussed about the procedure that was followed by the Constituent Assembly to make Indian Constitution. In this video, we discuss what are the most important and specialized features of Indian Constitution. To understand this topic, you should observe one thing. We can see different types of books in bookstalls. Each and every book has its unique features. The features may be its cover page, its font, what is used in the book, pictures, colors, types of diction, and many things. Every book has its own unique features. As well as Constitution is also nothing but a book of rules. A book of rules. It is the basic rule book of a nation. Already we discussed the point. So that Constitution has also its unique features as well as other constitutions have. What are the major important features of our Indian Constitution? In this video, we discuss about the features of Indian Constitution, and there is a chance to ask one question about the features of Indian Constitution. And also, there is a chance to ask a question in group 1 minds or civil minds, like what are the features of Indian Constitution and what is the main criticism on Indian Constitution while it was being made. Coming to the points, our Indian Constitution is one of the most beautiful constitutions in the world, because the critics criticized that our Indian Constitution is nothing but a bundle of borrowings. Of course, it may be true. Why? Because the most of the content of the Indian Constitution is borrowed from somewhere. It may be borrowed from 1935 Act, some content are borrowed from American Constitution, some content are borrowed from British Constitution, some content are borrowed from other constitutions of the world. That's why our Constitution is criticized as a bundle of borrowings, even though whatever the content is borrowed from other constitutions is suitable to the present scenario of Indian philosophical system. Our national leaders, our constitutional members, our intellectuals prefer that whatever the content is instructed in other constitutions, it is not at all a wrong method to borrow. Why? Because it is suitable to our present scenario. That's why there are many borrowed things in the Constitution. Coming to the point of Indian silent features, the first silent feature is Indian Constitution is the lengthiest and written constitution. The lengthiest and written constitution. This is the first silent feature. Why Indian Constitution is lengthiest? Already we discussed earlier, our Constitution consisting of 395 articles. It consisting of 395 articles, and
22 parts and 8 schedules in the original constitution. When the constitution was adopted by Constituent Assembly on November 26, 1949, it consists of 395 articles, 22 parts and 8 schedules. But today, the number of articles are increased to 465 articles, the number of parts are increased to 25, the number of schedules are increased to 12. That's why our Indian constitution has more content than other constitutions, and it took 2 years, 11 months, 18 days to complete to make the draft constitution. Rather than American constitution took only less than 4 months to complete it. Because of these reasons, because of this much of heavy content, our Indian constitution is the lengthiest constitution, and as well as it is a written constitution. Already we discussed it earlier. Our constitution is a completely man-made document. It was drafted by the drafting committee, and Prem Bihari Narayan Raisda, the calligrapher of our Indian constitution, had made it in italic font, and Nandalal Bose and Ram Manohar added the beautiful things to our Indian constitution. That's why our constitution can be considered as the lengthiest constitution and written constitution. American constitution is the first written constitution in the world. Okay, coming to the next feature of our Indian constitution, that is preamble. The concept of preamble is borrowed from American constitution. The concept of preamble is borrowed from American constitution. Preamble is nothing but index of the constitution, or the gateway of the constitution, or the summary of the constitution, or the preface to the constitution, or the philosophy of the constitution. So preamble gives us the overall summary of the constitution, the main aims, the objectives, and the ideologies of our constitutional members are reflected in the preamble. Preamble is nothing but a summary of our Indian constitution. It can be considered as one of the most important features of our constitution, and preamble is a special lesson to us. We will discuss in detail about the preamble in upcoming classes. The next one, fundamental duties or fundamental rights is one of the most important feature of our Indian constitution. Fundamental rights, the concept of fundamental rights are borrowed from America. Fundamental rights are constituted in the third part of the constitution in between article number 12 to 35. Our constitution provided 6 fundamental rights to the citizens of India: right to equality, right to freedom, right to religious aspects, right to educational and cultural activities, right against exploitation. All these fundamental rights. The fundamental rights are promised by the Indian constitution, which gives a way to the citizens to improve themselves, to live freely in the country. If we don't have rights, then the citizens may not live freely in the society. In our India, the citizens are enjoying all types of rights. The rights may be right to freedom of speech, right to freedom of live, right to freedom of take any occupation or profession. All types of rights are enjoying in India. Those rights are provided by the Constitution of India. Not like other constitutions, fundamental rights are strongly and perfectly protected by the Supreme Court of India. Next one is DPSP, Directive Principles of State Policy. The concept of Directive Principles of State Policy is borrowed from Ireland. Directive principles are the guidelines given to the governments how to administrate the state. What the steps the governments have to take while they make a law, or the parliaments are enacting a law. These DPSPs are paved a way to the governments to administrate and to build a welfare state. DPSPs are giving some guidelines to the governments, like the state government or central government, how to provide the welfare system in a state, how to make a state welfare, how to make a state developed, how to make a state very advanced. These guidelines are exclusively mentioned in our constitution in part number 4 in between articles number 36 to 51. This is also one of the most important features of our Indian constitution. Next thing is fundamental duties. Fundamental duties. The concept of fundamental duties is not laid in the original constitution. Fundamental duties are not laid in the original constitution when it came into force. But the concept was added to the constitution in 1976 by the 42nd Amendment Act as per the recommendations of different types of committees. The concept of fundamental duties is borrowed from USSR. The original constitution did not have fundamental rights and fundamental duties. Later it was added to the Indian constitution in 1976 by 42nd Amendment Act. Right now there are 11 fundamental duties mentioned in the Indian constitution. These fundamental duties help the Indian citizens how to behave in the society, how to respect our constitution, how to respect our national leaders, how to follow the methods followed by the national leaders, how to cooperate to the government, how to preserve the nature and natural resources, all these things. 11 types of fundamental duties are mentioned in Indian constitution in part number 4A under the article number 51A. These fundamental duties are added to the constitution in 1976 by 42nd Amendment Act, Constitutional Amendment Act. The fundamental duties are added to the Indian Constitution based on the recommendations of Justice Swaran Singh Committee. Justice Swaran Singh Committee recommendations, important. Fundamental duties are incorporated to the Indian Constitution based on the recommendations of Swaran Singh Committee. Okay, the concept of fundamental duties are borrowed from USSR. At present, there are 11 fundamental duties in our Constitution. Similarly, DPSP are borrowed from Ireland. They are mentioned in part number 4 and in between articles number 36 to 51. Directive principles of state policy guided the government to build the welfare state. Fundamental rights are laid down in part number 3 of the Constitution in between article number 12 to 35. The concept of fundamental rights is borrowed from USA Constitution. Preamble, the concept of preamble is borrowed from American Constitution, but it is the preface to the Constitution and it is also a part of Indian Constitution. Coming to the next feature of our Indian Constitution. Our Indian Constitution is both rigid and flexible Constitution. Important thing. Our Constitution is both rigid and flexible Constitution. So already we discussed earlier in previous classes in types of constitutions. A rigid constitution is a constitution which can be amended with a special majority, which cannot be amended as an ordinary law amended. A flexible constitution is a constitution which can be amended with simple majority, or flexible constitution is a constitution which can be amended as an ordinary law amended. So rigid constitution needs a special majority to amend. Rigid constitution needs a special majority to amend. A flexible constitution needs a simple majority to amend. But our constitution has both features. Some parts of our Indian Constitution, like fundamental rights, like DPSP, like fundamental duties, like presidential election, such things can be amended with only the special majority, means 2/3 majority of the parliament. But meanwhile, some parts of our Indian Constitution, like citizenship, like states reorganization, like official languages, such things can be amended with a simple majority. So that's why some parts of our Indian Constitution can be amended with special majority, some things can be amended with simple majority. If a constitution is amended with simple majority, it is flexible. If a constitution is amended with special majority, it is rigid. But our constitution has both two features. That's why our Indian Constitution is not completely a rigid constitution, not completely a flexible. Our constitution is both rigid and flexible. Here, one more thing you have to remember. The most rigid constitution in the world is American Constitution. The most flexible constitution in the world is Britain Constitution. And another feature of our Indian Constitution is universal franchise. Universal franchise. Universal franchise means in our election system, the right to vote is given to the citizens not based on the race, religion, sex, caste, and so on, but it is given to the citizens on the grounds of age only. Before 1989, the age to get right to vote is 21 years. In 1988, by the 61 Amendment Act, the age was reduced from 21 years to 18 years. Today, in India, the citizens who are 18 completed have the right to vote. This is called universal franchise. 18 years is the fundamental base to give the right to vote to the Indian citizens. If a person completes 18 years, he is considered as a citizen of India because he has the right to elect the government. He has the right to vote. Earlier, it was 21 years, but by the 61st Amendment Act, it was reduced to 18 years in 1989. Then the Prime Minister was Rajiv Gandhi. During Rajiv Gandhi tenure, the age of right to vote is reduced from 21 years to 18 years by the 61st Amendment Act. Here, amendment number, Prime Minister Rajiv Gandhi, here important things. Okay, now in India, the universal franchise is applicable to the all citizens who completed 18 years. Okay, next, coming to the next one, single citizenship. Single citizenship. In India, only single citizenship is permitted by the Constitution of India. Citizenship, the concept of citizenship is derived from or borrowed from Britain. Citizenship is mentioned in Indian Constitution in part number 2 in between articles number 5 to 11. Before 2019 August 5, Jammu Kashmir, a special status state, has only the double citizenship. As per article number 3, citizenship is derived from or borrowed from Britain. Citizenship is mentioned in Indian Constitution in part number 2 in between articles number 5 to 11. Before 2019 August 5, Jammu Kashmir, a special status state, has only the double citizenship. As per article number 370, as per article number 35A, the Jammu Kashmir has provided some other benefits with the agreement between what was held in 1952. There was a single citizenship was in implementation. But when article number 370, article number 35A was abolished in 2019 on August 5, even Jammu Kashmir is also reorganized as 2 union territories. Now, all over India, there is only one citizenship. One nation, one citizenship. In earlier, only Jammu Kashmir is a state with double citizenship, but now all states, including union territories, has only single citizenship. The concept of citizenship is borrowed from Britain, and it is mentioned in the Constitution in part number 2 and in articles between in articles number 5 to 11. Okay, so you should remember that. Next, Indian silent features of Indian Constitution are discussing. So next, another features of our Indian Constitution is our Indian Constitution provides a parliamentary government in India. In India, the concept of parliamentary form of government is borrowed from Britain. The concept of parliamentary form of government is borrowed from Britain. What is the parliamentary form of government means? You should remember one thing. Every government in modern democratic states has 3 pillars, 3 branches. 1 executive, 2 legislative, 3 judiciary. Legislative is a branch of government which enacts laws. Executive is a branch of government which implements the acts enacted by the legislature. Judiciary is the 3rd pillar of the government which summarize the acts enacted by the legislature or implemented by the executive. These are the 3 main pillars of any government in the modern democratic states. In India, both the legislature and executive are interdependent. They are controlled each other. If legislature overcome its limit, then executive controls it. If executive crosses its limits, then legislature controls it. And they are interlinked and they are interdependent. If legislature and executive are interlinked and interdependent, then such type of government is known as parliamentary form of government. In the parliamentary form of government, there are 2 heads. One, head of the state and head of the government. Head of the state acts as a nominal and head of the government acts as actual, real authority. In India, president is the head of the state, prime minister is head of the government. Here, president, even though he is the head of the state, he acts as just as a nominal authority. But actually, all the things are being authorized and organized and controlled by the prime minister only. All the powers actually are vested in the name of the president, but actually all those things are implemented by council of ministers headed by prime minister. So that in a parliamentary form of government, there are 2 types of heads: head of the state, head of the government. At the state level also, head of the state is governor, head of the government is chief minister. Governor acts as a nominal authority and chief minister and his council of ministers acts as a real authority. So this is the parliamentary form of government. But in America, there is presidential form of government. Okay, the concept of parliamentary form of government is derived from Britain. In this form of government, there are 2 types of heads: head of the state. He is the nominal authority in the country or the state. 2, head of the government. He is the actual authority of the state or government, real or actual. At central level, head of the state is president, head of the government is prime minister. At state level, head of the state is governor, head of the government is chief minister and his council of ministers. So like that, there are many features. Whatever we can say about our Indian Constitution is nothing but a feature of our Indian Constitution. And coming to the next one, independent judiciary system. Independent judiciary system. It is also one more salient feature of our Indian Constitution. The concept of independent judiciary system is borrowed from America Constitution. Actually, in our India, both Supreme Court and High Courts, other district courts are completely separated from executive. In DPSP, in Directive Principles of State Policy, as per article number 50, the judiciary is completely separated from executive because if it is not separated from executive, it may be corrupted, it may be impacted, and it may be some manipulated. If it is separated from the executive, then it can act as an independent body and give such beautiful verdicts. So that in India, the judiciary system is independent and unique. Supreme Court is the highest judicial body in our India at central level. High courts are the highest judiciary bodies at state level. Okay, this is also one more feature of our Indian Constitution. All these are the different types of salient features in our Indian Constitution. But there is some criticism also on our Indian Constitution. And one more thing is, in Indian Constitution, the powers are distributed between state government and central government with three lists: list A, list B, and concurrent list. List 1, list 2, and concurrent list, and residuary powers. So, distributing of powers between state and central government is a feature of federal system. Meanwhile, if all the powers are vested in the name of central government, it is unitary government. Then what about India? Is India a federal? Is India a unitary? Indian Constitution is nothing but a feature of our Indian Constitution. And coming to the next one, independent judiciary system. Independent judiciary system. Independent judiciary system. It is also one more salient feature of our Indian Constitution. The concept of independent judiciary system is borrowed from America Constitution. Actually, in our India, both Supreme Court and High Courts, other district courts are completely separated from executive. In DPSP, in Directive Principles of State Policy, as per Article number 50, the judiciary is completely separated from executive, because if it is not separated from executive, it may be corrupted, it may be impacted, and it may be some manipulated. If it is separated from the executive, then it can act as an independent body and give such beautiful verdicts. So that in India, the judiciary system is independent and unique. Supreme Court is the highest judicial body in our India at central level. High courts are the highest judiciary bodies at state level. Okay, this is also one more feature of our Indian Constitution. All these are the different types of salient features in our Indian Constitution. But there is some criticism also on our Indian Constitution. And one more thing is, in Indian Constitution, the powers are distributed between state government and central government with three lists: list A, list B, and concurrent list. List 1, list 2, and concurrent list, and residuary powers. So, distributing of powers between state and central government is a feature of federal system. Meanwhile, if all the powers are vested in the name of central government, it is unitary government. Then what about India? Is India a federal? Is India a unitary? Then what about India? Is India a complete federal state? Is India a complete unitary state? Let us discuss. India is not a complete federal state. It's not complete unitary state. Federal state means where the powers are distributed equally between state government and central government. In the world, America is the most federal state. Why? Because there the central government and the state government are given equal powers. Central government has one individual constitution and each state has their own constitutions. In central there is a citizenship, and states there is another citizenship. So, but in our India, powers are distributed between state and central, but not equally. In the 7th schedule in our Indian Constitution, the powers distribution between state and central are clearly mentioned. There three types of lists are mentioned. One, central list, state list, and concurrent list. Right now, the central list consisting of 98 items, the state consisting of 59 items, and the concurrent list consisting of 52 items, and the residuary powers are vested in the name of central government. So, as per the 7th schedule of our Indian Constitution, the powers are distributed between state and central in three types of list. Central is consisting of 98 items. So 98 powers are given to the central government. Those are currency, banking, insurance, RBI, foreign affairs, defense affairs, science and technology. Such things are given to the central government. Whereas 59 items are in state list right now. Those are comes under state list, or some examples are agriculture, public health, police system, all these things. For example, 59 items are comes under state list. Concurrent list consisting of 52 items. Concurrent list consisting of 52 items means education, marriage, divorce, forest, such things comes under electricity, such things comes under the concurrent list. In the concurrent list, whatever the items are mentioned, both central government and state government have equal powers to enact any act on these 52 items. If both central government and state government enacts a law over the concurrent list items, then ultimately the central government's law came into existence. So that the powers are distributed but not equally. State government only has 59 items, whereas the central government have 98 items. So right now, these are the three types of list. And the residuary powers like space technology, ISRO, such things are vested in the name of central government. So powers are distributed but not equally. That's why India is a federal state, as well as the many powers are vested in the name of central government. So that's why there is a centrifugal central government, the more stronger than the states. The centrifugal form of government is formed in India. That's why India is both federal and unitary. In other terms, India is a federal state with unitary qualities. India is a federal state with unitary qualities. So India is not completely a federal state. India is not complete and unitary state, but India is a federal state with unitary qualities. This is another feature of our Indian Constitution. Coming to the next one, three-tier government. Three-tier government. In India, the form of the government is decentralized. The form of the government is laid down at three stages: central government, state government, and local governments. Local governments are of two categories: rural panchayat raj systems and urban panchayat raj systems. So now the powers are decentralized to the Grama Panchayati level. From Rashtrapati Bhavan to Grama Panchayati level, the powers are distributed. Hence, there are three-tier system of government in India. So all these things are the most important salient features of our Indian Constitution. And local governments. Local governments are of two categories: rural panchayat raj systems and urban panchayat raj systems. So now the powers are decentralized to the Grama Panchayati level. From Rashtrapati Bhavan to Grama Panchayati level, the powers are distributed. Hence, there are three-tier system of government in India. So all these things are the most important salient features of our Indian Constitution. Indian Constitution at a glance. Parts and schedules of the Constitution. In previous class, we discussed the salient features of Indian Constitution. In this video, we'll learn what are the content in our Indian Constitution, how the content is divided under parts and schedules. So first, coming to the parts of the Indian Constitution. What is part of a Constitution? Part is nothing but the partition of articles. Part is nothing but partition of articles. There are 395 numbered articles, but overall there are 465 articles. So these articles are partitioned. They are divided into a group based on the topic which they discussed. So that's why part is nothing but partition of articles. In the original Constitution, there are 22 parts. All articles, 395 articles, are divided into 22 parts. Still today, the number is still 22. But by the time passing, as per the demands of our nation, some parts are added. Some parts or some articles, some schedules may be deleted. Seventh part is deleted, repealed, and some parts are added to the Constitution. If we want to add a part to the Constitution, no additional number is given to that part, but the number is added with English alphabet letter. For example, 4A, the part number 4A is added, but it has not given any another new number, but it is added with English capital letter alphabet. So in an Indian Constitution, if we want to add any article or any part, then we give to the part with additional English alphabet letter, so that the number cannot be changed, but the number of is changed. So still today, there are 22 numbered parts. Number is permanent, 22 is the permanent number, but number of is different. Number of parts in our Constitution is today is 25. The numbered parts are 22. You should observe that difference. Okay, coming to the points. So now there are 25 parts in our Indian Constitution, but actually the numbered parts are only 22. But in Indian Constitution, some parts are added. 4A is added, 9A, 9B, and 14A were added, and 7th part was deleted from the Indian Constitution. Okay, coming to the point, which part deals with which subject and the articles covered? We have to remember. Okay, coming to the first one. First part, the Union and its territory. The Union and its territory. Articles covered from 1 to 4. First part deals with the Union and its territory, means what is India, how India is formed, how the states are reorganized, how the states are formed or divided. All these things are mentioned in this first part. So the first part deals with the Union and its territory. Articles are covered from 1 to 4. Okay. Coming to the next one, citizenship. The second part is citizenship. Articles covered from 5 to 11. From 5 to 11. Third part deals with fundamental rights. Fundamental rights. Articles covered from article number 12 to article number 35. And fourth part deals with directive principles of state policy. Directive principles of state policy. Articles covered from article number 36 to citizenship. Articles covered from 5 to 11. From 5 to 11. Third part deals with fundamental rights. Fundamental rights. Articles covered from article number 12 to article number 35. And fourth part deals with directive principles of state policy. Directive principles of state policy. Articles covered from article number 36 to 51. And part number 4A. Here, 4A. No another number is added, but the number is added with English alphabet letter. Whatever is added to the Indian Constitution, for that no additional number is given, but for that number the English alphabet letter is added newly. So that's why 4A is added. If we want to add anything into the Constitution, we must amend the Constitution. Okay, so here whenever a part or a schedule or an article is added to the Constitution, then we must remember the year and the Amendment Act number. Two things we should remember. So 4A deals with fundamental duties. Fundamental duties. The added article, the newly added article is article number 51A. No another number, only 51 and alphabetical A, 51A, the new article. Whatever the English capital letter is beside the number, it is nothing but the added one. Okay, so this fourth part, 4A part was added in 1976 by the 42nd Constitutional Amendment Act. Part number 4A is added to the Constitution in 1976 by the 42nd Constitutional Amendment Act. 4A deals with fundamental duties under the article number 51A. Okay, coming to the next one, fifth part. And one more thing you have to remember, the 4th A part is the smallest part in the Indian Constitution because it consisting only one article. Next, coming to the fifth one, Union Government. Union Government. This part consisting of article number 52 to 151. Article number 52 to 151. Hence, it consisting more articles. That's why it is considered as the largest part of the Constitution. Part number 5 is considered as a largest part of the Constitution because it consisting more articles. But part number 5 is again divided into 5 chapters. Part number 5 is again divided into 5 chapters. Those are chapter 1, the executive. Acts, articles number 52 to 78, and chapter number 2, Parliament, articles covered from 79 to 122, and chapter 3, Legislative powers of the President, article covered number 123. Chapter 4 is the Union Judiciary. The Union Judiciary, articles covered 124 to 147, and chapter number 5 is COG, articles covered 148 to 151. Legislative powers of the President, article covered number 123. Chapter 4 is the Union Judiciary. The Union Judiciary, articles covered 124 to 147, and chapter number 5 is COG, articles covered 148 to 151. Okay, part number 5 is again divided into 5 chapters. Part number 5 deals with union government, covering articles number 52 to 151, is again further divided into 5 chapters. The chapters are, the first chapter of 5th part is the executive. The executive, which deals with the president, vice president, prime minister, council of ministers, and attorney general, all these things. The executive articles covered from 52 to 78. The second chapter of part number 5 is parliament, consisting of Lok Sabha, Rajya Sabha, and president. Articles covered 79 to 122. Third chapter of part number 5 is legislative powers of the presidents. Article covered is article number 123. Fourth chapter of part number 5 is union judiciary, that is Supreme Court. Articles covered 124 to 147. And fifth chapter is controller and auditor general of India, COG. Articles covered 148 to 151. So these 5 chapters also you should remember. Whatever the part number 5 is matters with subject, and also you have to remember these 5 chapters also. Part number 5 is divided into 5 chapters. Articles covered from 52 to 151, consisting of more articles. That's why it is called as the largest part of our Indian Constitution. Coming to the 6th part, deals with state government. Articles covered, articles from 152 to 237. Part number 6 is considered as the second largest part of our Indian Constitution. Part number 5 is the largest part. Part number 6 is the second largest part of our Indian Constitution. The 6th part further divided into 5 new chapters. Those are, here I am writing. Chapter number 6 deals with state government, is again further divided into 6 chapters. Number 1 is Chapter 1, General Matters, Article number 152. Chapter 2, the Executive of the State Government. Article number 153 to 167. Chapter number 3, the State Legislature. Further divided into 5 new chapters. Those are, here I am writing. Chapter number 6 deals with state government, is again further divided into 6 chapters. Number 1 is Chapter 1, General Matters, Article number 152. Chapter 2, the Executive of the State Government. Article number 153 to 167. Chapter number 3, the State Legislature. Deals with article number 168 to 212. And 4th chapter is Legislative Powers of the Governor. Deals with articles covered 213. And 5th part is the High Courts. Articles covered 214 to 5th is Legislative Powers of the Governor. Deals with articles covered 213. And 5th part is the High Courts. Articles cover 214 to 232. The 6th part, with article number 160, articles cover 213, and 5th part is the High Courts. Articles cover 214 to 232. The 6th part, again divided into 5 new chapters. First chapter deals with general topics. Article covered 152. Second chapter is the state executive. Article covered 153 to 167. Third chapter is the state legislature. Articles covered from 168 to 212. The 4th chapter is legislative powers of the governor. Article covered 213. And 5th chapter is the state high courts. Articles covered from article number 214 to 237. And 7th part. 7th part is no more in our Indian Constitution. It was deleted from the Constitution, but in earlier it was deleted in 1956 by the 7th Amendment Act. The 7th part, which deals with the states under the Part B of the Schedule number 1, is deleted from Indian Constitution in 1956 by 7th Amendment Act. Here I am mentioning 7th part is deleted in 1956 by 7th Constitutional Amendment Act, which deals with the Part B states of the first schedule of the Constitution, but it is no more in our Indian Constitution. Okay, and it is consisting of article number 238. So the article is also deleted. So article number 238 is no more in Indian Constitution. Article 7, part number 7 is no more. Article number 238 is also no more in Indian Constitution. So therefore, I am not mentioned 7th part and article number 238 here. Next, coming to the 8th part. 8th part deals with the Union Territories. The Union Territories. Articles covered 239 to 242. Coming to the ninth part deals with the panchayatis, the panchayat Raj system. The panchayatis, ninth comes under part number 9. Articles cover 243A to 243O. 243O. And part number 11A deals with the municipalities. From article number 243P to article number 243ZG. And part number 9B deals with the cooperative societies. The cooperative societies. Articles cover 243ZH2. From 243A to 243O. 243O. And part number 11A deals with the municipalities. From article number 243P to article number 243ZG. And part number 9B deals with the cooperative societies. The cooperative societies. Articles cover 243ZH2, 243ZT. So here, seventh part is deleted. Eighth part deals with union territories. Articles cover 239 to 242. And ninth part deals with the gram panchayatis. Articles cover 243 to 243O. Here, some articles are added, 243A, 243B, up to 243O. All these articles are added in 1992 by the 73rd Constitutional Amendment Act. The ninth part was re-added to the Indian Constitution with adding more articles in 1992 by the 73rd Constitutional Amendment Act. But the 73rd Constitutional Amendment Act came into existence in 1993. Actually, this act was introduced the bill was introduced in the Parliament in 1992, but the 73rd Constitutional Amendment Act came into existence from 1993, April 24. Coming to next one, 9A. This is newly added to the Constitution, deals with the municipalities. This 9A is added to the Constitution in 1992 by the 74th Constitutional Amendment Act. Actually, the 74th Constitutional Amendment Act came into existence in 1993, June 1st. Okay, coming to the cooperative societies, 9th B. Cooperative societies comes under part number 9B. It was added to the Indian Constitution in 2011 by the 97th Constitutional Amendment Act. By the 97th Constitutional Amendment Act. Next, part number 10. Part number 10 deals with the scheduled and tribal areas. The scheduled and tribal areas. Articles covered, article number 244 and 244A. Coming to the part number 11, relations between article number 244 and 244A. Coming to the part number 11, relations between union government and state government, between state and center. Articles covered, article number 245 to article number 263. The 11th part further divided into two chapters. One, legislative relations between state and center. It deals with article number 245 to 255. Second chapter is administrative relations. Articles cover 256 to 263. So part number 11 deals with the relations between state government and central government. Articles covered in between 245 to 263. The 11th part further divided into two chapters. One, legislative relations between state and center. Articles covered from 245 to 255. And second chapter is administrative relations between state and center. Articles covered from 256 to 263. And part number 12 also deals with the relations between state and center of financial relations. So part number 12, relations between union government and state government. Here, part number 12, finance, property, contracts and suits. Articles cover 264 to 300A. Further, this chapter is classified into 4 new chapters. One is financial relations between state and center. Articles cover 264 to 291. Second chapter, borrowing. Articles cover 292 and 293. And third chapter is property, contracts, suits, liabilities, obligations. Articles number 294 to 300. Chapter number 4 is right to property. Article number 300A. This is 12th part of the Indian Constitution. Coming to the 13, trade, commerce, and intercourse within the territory of India. Articles cover 301 to 307. Article number 14, services under the state government and central government. Article covered 308 to 323. Again, this is classified into 2 chapters. Chapter 1, services, 308 to 314. Chapter 2 is public service commissions, 315 to 323. Coming to the 14A is tribunals. Articles cover 323A and 323B. It was added to the Indian Constitution chapters. Chapter 1, services, 308 to 314. Chapter 2, under the state government and central government. Article covered 308 to 323. Again, this is classified into 2 chapters. Chapter 1, services, 308 to 314. Chapter 2 is public service commissions, 315 to 323. Coming to the 14A is tribunals. Articles cover 323A and 323B. It was added to the Indian Constitution in 1976 by the 42nd Constitutional Amendment Act. Coming to the 14A is tribunals. Articles cover 323A and 323B. It was added to the Indian Constitution in 1976 by the 42nd Constitutional Amendment Act. Tribunals deals with Article number 323A and 23B. 15, Election Commission or elections. Article number 324 to 329. 329A. Next, 16th part deals with special provisions related to Election Commission Act. It was added to the Indian Constitution in 1976 by the 42nd Constitutional Amendment Act. Tribunals deals with Article number 323A and 23B. 15, Election Commission or elections. Article number 324 to 329. 329A. Next, 16th part deals with special provisions relating to certain classes, means certain classes. Special provisions provided for the SCs, STs and Anglo Indians, like that. Articles covered, article number 330 to article number 342A. Part number 17, official language. Official languages. Articles covered 343 to 351A. It is further divided into 4 chapters. Chapter 1, language of the Union. Language of the Union, article number 343 and 344. Second chapter is regional languages. Regional languages, article number of the languages. Articles covered 343 to 351A. It is further divided into 4 chapters. Chapter 1, language of the Union. Language of the Union, article number 343 and 344. Second chapter is regional languages. Regional languages, article number 345 to 347. Chapter number 3, languages used in Supreme Court, High Court and so on, 348 to 349. And special directives, chapter 8, regional languages, article number 345 to 347. Chapter number 3, languages used in Supreme Court, High Court and so on, 348 to 349. And special directives, chapter number 4, article number 350 and 351. Next, 18th part 4 and so on, 348 to 349. And special directives, chapter number 4, article number 350 and 351. Next, 18th part, emergency provisions. Emergency provisions, articles covered 352 to 360. Part number 19, miscellaneous provisions, emergency provisions, articles covered 352 to 360. Part number 19, miscellaneous articles cover 361 to 367. Part number 20, amendment of the Constitution. Amendment of the Constitution, articles cover 368 only. 21, temporary, transitional and special provisions. Article cover 369 to 329. And last 22 part is short title, commencement, authoritative text in Hindi, 393 to 395. These are the 22 overall 25 parts. These are the 25 parts of Indian Constitution. You should remember each and everything by practicing more and more times on the rough paper. Again, I will read each and every part by explaining what it actually deals with. So actually you have to remember one thing. The number is here 22 about parts. So the numbered parts is 22. And the last number of the last article of our Indian Constitution is 395. It means numbered articles in our Indian Constitution is 395. But number of is 465 plus. So the number what is inserted in original Constitution is not changed at all. But number of is changed. So whenever the Constitution is added, the new articles, the new parts are added to the Constitution by adding English alphabet letter. So that the original number cannot be changed, but the total number is only changed. So in our Indian Constitution, the numbered parts 22, but the number of parts is 25. The numbered parts is 22, but the number of parts is 25. The numbered articles is 395, but number of articles are 465 plus. The numbered articles are 395, but the number of articles are in our Indian Constitution are 465 articles. What is inserted in original Constitution is not changed at all, but number of is changed. So whenever the Constitution is added, amendment of the constitution only. 21 temporary, transitional and special provisions. Article cover 369 to 329. And last 22 part is short title, commencement, authoritative text in Hindi, 393 to 395. These are the 22 overall 25 parts. These are the 25 parts of Indian Constitution. You should remember each and everything by practicing more and more times on the paper. Again, I will read each and every part by explaining what it actually deals with. So actually you have to remember one thing. The number is here 22 about parts. So the numbered parts is 22. And the last number of the last article of our Indian Constitution is 395. It means numbered articles in our Indian Constitution is 395. But number of is 465 plus. So the number what is inserted in original Constitution is not changed at all. But number of is changed. So whenever the Constitution is added, the new articles, the new parts are added to the Constitution by adding English alphabet letter. So that the number, the original number cannot be changed, but the total number is only changed. So in our Indian Constitution, the numbered parts 22, but the number of parts is 25. The numbered parts is 22, but the number of parts is 25. The numbered articles is 395, but number of articles are 465 plus. The numbered articles are 395, but the number of articles are in our Indian Constitution is 465 articles. Okay, now once again I repeat all the 25 parts with explanation. Listen to me carefully. The first part deals with union territory and its name. So the union, its territory, deals with the name of our country, the territory parts of our country, means states and union territories, and the states reorganization. All these things comes in the first part, covered at number 1 to 4. Second part, citizenship. There is single citizenship in our India. So it deals with the citizenship, how the citizenship acts are enacted by the parliament, how they amend. All these things comes in the second part. Articles covered 5 to 11. Third part is fundamental rights. The 6 fundamental rights, their provisions, their details, their applications, their limits. All these things are discussed in the third part. Articles covered 12 to 35. Fourth part is directive principles of state policy. Covers article number 36 to 51. And 4A, this is the new part added to the Indian Constitution in 1976 by 42nd Constitutional Amendment Act. That is fundamental duties. Article covered 51A. This is the smallest part of our Constitution. Fifth part is the largest part, that is deals with Union government. Article covered 52 to 151. The fifth part again divided into 5 chapters. Chapter 1 deals with executive. Chapter 2 deals with parliament. Chapter 3 deals with the legislative powers of the president. Chapter 4 deals with the judiciary, union judiciary, Supreme Court. And chapter 5 deals with COG. Sixth chapter deals with state government. This is the second largest part of our Indian Constitution. Articles covered 152 to 237. The sixth part further divided into 5 new chapters. First part was general topics, second topic the state executive, the third chapter the state legislature, the fourth one legislative powers of the governor, fifth one is the high courts of the state government. And seventh part was related from the Indian Constitution in 1956 by the 7th Constitutional Amendment Act, which deals with the part B states of the first schedule of the Constitution, but it was deleted, and its related article number 238 is also deleted from the Constitution. Eighth part deals with Union territories, article cover 239 to 242. Ninth part deals with Grama Panchayatis. Here, some articles are newly added to the Indian Constitution in 1992 by the 73rd Constitutional Amendment Act. Articles covered are 243 to 243A to 243O. And 9A deals with the municipalities. It was also added to the Indian Constitution in 1992, 74th Constitutional Amendment Act. Articles cover 243P to 243ZG. 9B deals with the cooperative societies. It was added to the Constitution of India in 2011 by the 97th Constitutional Amendment Act. Articles cover 243ZH to 243ZT. 10th part deals with the scheduled and tribal areas and their administration. Articles cover 244 and 244A. 11th, 12th and 13th, 3 parts deals with the relations between state government and central government, about legislative relations, administrative relations and financial relations. So part 11 deals with the relations between state government and central government. Articles cover 245 to 263. This 11th part further divided into 2 chapters. One, the first chapter deals with the legislative relations of state and central government. Articles cover 245 to 255. The second chapter is administrative relations between state and central. Articles cover 256 to 263. 12th part deals with the financial relations between state and central, at the same time property, contracts and suits. Article 264 to 300A. It was further divided into 4 chapters. Chapter 1 finance, 264 to 291. Second chapter borrowing, 292 and 293. Third part, property, contracts, suits, liabilities and other things, 294 to 300. Fourth part is right to property, article number 300A. 13th part is trade, commerce and intercourse within the territory of the states, article number 301 to 307. 14th part is deals with the services of the state government and central government, means government employees. It deals with the government employees. It further divided into two chapters. First one, services, 308 to 314, and second chapter deals with public service commissions, means Union Public Service Commission, Joint Public Service Commission and State Public Service Commission. Articles cover 315 to 323. 14A deals with tribunals. It was added to the Indian Constitution in 1976 by the 42nd Constitutional Amendment Act. Articles cover 323A and 323B. And 15th part deals with elections and election commission. Articles cover 324 to 329A. And 16th part deals with the special provisions provided to the certain classes of SCs, STs and Anglo-Indians. Article 330 to 342A. And 17th part official languages. Articles cover 343 to 351A. Further, it was divided into four chapters. First chapter is language of Union government. Second chapter is regional languages. Third chapter is language used in Supreme Court, High Court and so on. And fourth chapter is special directives. 18th part deals with emergency provisions. Articles cover 352 to 360. And 19th part miscellaneous, means special provisions to the president, governor and so on. Articles cover 361 to 367. And 20th part is the smallest part of our Indian Constitution, consisting only one article. Amendment procedure of the Constitution, consisting article number 368. And 21 part temporary, transitional and special provisions. Special provisions provided to the Jammu, Kashmir, Nagaland, Manipur, Andhra Pradesh and so on, many states. Whatever the special provisions provided to the states. All these things comes under 21 part. Articles cover 269 to 392. And the final part, last part of the Constitution is short title, commencement date and authorized text in Hindi. All these things comes under 22 part. Articles covered 395 to 390, 393 to 395. Here, one thing you have to remember, numbered parts in Indian Constitution is 22, but number of parts 25. Numbered articles 395 and the number of articles 464 articles. This is all about parts of our Indian Constitution. Next, in the continuation of parts and schedules of the Indian Constitution. Let us discuss about schedules of our Constitution. Before going into the detail, let us know what is a schedule. A schedule is nothing but an additional information. A schedule provides us additional information related to a particular part or particular article. So it is nothing but appendix to the particular issue or particular topic. So that's why schedules are the additional information giving parts of the Constitution. In original Constitution of India, there are 8 schedules. Later, 4 new schedules were added to the Indian Constitution. Right now, we have 12 schedules in India Constitution. So let us discuss about what are the various types of schedules, what the subject matters it consists, and what are the articles covered. Coming to the first one, schedule number 1. Schedule number 1 deals with the names and territories of the states and union territories in India. First schedule deals with names of states and their jurisdiction, union territories and their extent. So first schedule provides the information of list of all states and list of all union territories and their boundaries and their extent. So here there is a relation between part 1 and schedule number 1. Part 1 and schedule number 1. If a state is reorganized, if a state is newly formed, then first schedule must be amended. Why? Because if a state is newly added, then the number of states increased. So automatically the new state's name and its alphabetical order, its extent will be added to the first schedule. So we can get the full information of states, UTs, their names and their extent in the first schedule. Articles covered are 1 and 4. 1 and 4. If a state is reorganized, then first schedule must be amended. As per article number 3, states are reorganized. As per article number 3 of the constitution, states are reorganized. When a state is reorganized, then the state's extent changed, the state's name changed, the number of state is changed, the alphabetical order is changed. All these changes are again added to the first schedule. So remember this point, very important also. When a state is reorganized, first schedule of the constitution must be amended. And the second schedule deals with provisions of salaries, allowances and other provisions provided for some constitutional authorities. Second schedule deals with provisions related to the salaries and allowances and privileges. Provisions that are provided for some constitutional authorities, their salaries, allowances and their privileges. Articles covered are here. Article number 59, 65, 75, 97, 125 and 148, 158, 164, 186 and 221. The second schedule deals with the provisions of salaries, allowances and privileges provided for particular constitutional authorities. Such particular constitutional authorities are President of India, Governor of the states, and as well as Supreme Court judges, High Court judges, Speaker of Lok Sabha, Deputy Speaker of Lok Sabha, Chairman of Rajya Sabha and Deputy Chairman of Rajya Sabha, Speaker of Assembly and Deputy Speaker of State Assemblies, Chairmen and Deputy Chairmen of State Legislative Councils, and COG. All these 9 types of members, 9 types of constitutional authorities are mentioned in second schedule. Only about the 9 constitutional authorities and their salaries, allowances and privileges are mentioned in the second schedule. These 9 names you should remember. Why? Because questions may be asked like this. Which of the following constitutional persons and their salaries, allowances are not mentioned under the second schedule? Then you should remember all these 9 names. These are President of India, Governors of the state government, Supreme Court judges, High Court judges, COG, Controller and Auditor General of India, Speaker and Deputy Speaker of Lok Sabha, Chairman and Deputy Chairman of Rajya Sabha, Speaker and Deputy Speaker of State Assemblies, Chairman and Deputy Chairman of State Legislative Councils, So these 9 types of constitutional authorities about their salaries, allowances and privileges are mentioned under schedule number 2. So you should remember all these 9 types of constitutional bodies. Salary of president, salary, allowance and privileges of the presidents are mentioned under second schedule. Salary of governor, salary of Supreme Court judges, salary of High Court judges, salary and allowances of COG, salary of Speaker and Deputy Speaker of Lok Sabha, salary and allowances of Chairman and Deputy Chairman of Rajya Sabha, salary and allowances and privileges of Speaker and Deputy Speaker of State Assemblies, salaries, allowances and privileges of Chairman and Deputy Chairman of State Legislative Councils. These 9 categories of constitutional bodies, their salaries, their privileges, their allowances and their emoluments are mentioned under the schedule number 2. Coming to the third schedule, oath and affirmations. Allowance and deal number, Chairman of State Legislative Councils, So the and Deputy Chairman of State Legislative Councils, So these 9 types of constitutional authorities about their salaries, allowances and privileges are mentioned under schedule number 2. So you should remember all these 9 types of constitutional bodies. Salary of president, salary, allowance and privileges of the presidents are mentioned under second schedule. Salary of governor, salary of Supreme Court judges, salary of High Court judges, salary and allowances of COG, salary of Speaker and Deputy Speaker of Lok Sabha, salary and allowances of Chairman and Deputy Chairman of Rajya Sabha, salary and allowances and privileges of Speaker and Deputy Speaker of State Assemblies, salaries, allowances and privileges of Chairman and Deputy Chairman of State Legislative Councils. These 9 categories of constitutional bodies, their salaries, their privileges, their allowances and their emoluments are mentioned under the schedule number 2. coming to the third schedule, oath and affirmations. Forms of oath or affirmations. Articles covered in this schedule are article number 75, 84, 99, 124, 146 and 173. (188) and 219. Forms of oaths. So here, 9 types of constitutional authorities. Their forms of oaths or affirmations are mentioned under the schedule number 3. Those are 1. The union ministers. Their oath or affirmation. The candidates. 219. Forms of oaths. So here, 9 types of constitutional authorities. Their forms of oaths or affirmations are mentioned under the schedule number 3. Those are 1. The union ministers. Their oath or affirmation. The candidates for election of parliament. The members of parliament. The judges of Supreme Court. The judges of High Court. The state ministers. The candidates for election of state assemblies. The members of state assembly. And 9th category is the judges of Supreme Court and the COG, Controller and Auditor General of India. In the second schedule, the salaries, allowances and privileges of 9 constitutional authorities are mentioned. In schedule number 3, the oaths or affirmations of 9 types of constitutional authorities are mentioned. The list is oaths of the union ministers, the oaths of the candidates for election for parliament, the oaths of the members of parliament, the judges of Supreme Court, the oath of judges of Supreme Court, the oath of judges of High Court, the state ministers, the candidates for election of the state legislature, the members of state legislature, and Controller and Auditor General of India. So, about the forms of oaths of these 9 members are mentioned under the schedule number 3. You should remember these 9 names. In general, a candidate who is contesting in a parliament elections or assembly election, while submitting nomination, he has to take oath before the returning officer. If he win the elections, if he become a member of parliament or a member of assembly, then he again take oath as a member of that legislature house. If he became a minister, if a member is taking as a charge of minister, then he take oaths for 2 times. If a person became as the President of India, about his oath and affirmation is not mentioned under second schedule. Oath of President, oath of Governor, and oath of Election Commissioner officers, oath of Attorney General, oath of Advocate General are not mentioned under the third schedule. Only the oath of state ministers and central ministers, the oath of MPs, MLAs and MLCs, the oath of Supreme Court judges and the oath of High Court judges, oath of COG, oath of contesting candidates are only mentioned under schedule number 3. Once again I repeat, oath of central ministers, oath of state ministers, oath of Supreme Court judges, oath of High Court judges, oath of contesting candidates to the Lok Sabha or Rajya Sabha, oath of contesting candidates of state legislative assembly or council and COG are mentioned under the schedule number 3. There is a chance to ask question like this: which of the following members and their oath, forms of oath are not mentioned under the schedule number 3? President, Governor, Attorney General, Advocate General, 1 and 2, 2 and 3, 3 and 4 like this. So to answer correctly, remember these 9 things. Okay. In second schedule,
Next, in the continuation of parts and schedules of Supreme Court, correctly 80. It's in second schedule. Next, in the 7 Rajya Sabha seats. So the number of Lok Sabha seats, there is an important line. Articles covered are 4 and 18. 4 and 80. There is an important line to remember. When a state is reorganized, then the population also shared or distributed between the newly formed state and the previous state. Then the number of seats, the number of legislative assembly seats, the number of Lok Sabha seats and the number of Rajya Sabha seats are also changed. For example, before the bifurcation of Andhra Pradesh, before 2014, the united Andhra Pradesh consisting of 18 Rajya Sabha seats, 18. After the bifurcation of the states, the Rajya Sabha seats are distributed between Telangana and Andhra Pradesh. Andhra Pradesh got 11 Rajya Sabha seats, whereas Telangana 7 Rajya Sabha seats. So the number is distributed between the two states. So the number is changed, modified, so that when a state is reorganized, then automatically 4th schedule must be amended. Why? Because number of Rajya Sabha seats is distributed and it is changed. So when a state is reorganized, then 1st and 4th schedule must be amended. I repeat once again, when a state is reorganized, 1st schedule and 4th schedule must be amended. Why? Because when a state is reorganized, its new name, its alphabetical order, its territory, its extent must be added to the 1st schedule. As well as when a state is formed, its number of Rajya Sabha seats are also to be mentioned in the 4th schedule. That's why 1st schedule and the 4th schedule must be amended when a state is bifurcated or reorganized. Coming to the 5th schedule. 5th schedule deals with the provisions relating to the administration and the control of scheduled areas and scheduled tribes. Administration of scheduled areas and scheduled tribes areas. Articles covered in this schedule is article number 244. Fifth schedule deals with the administration and control of the scheduled areas and scheduled tribes areas in India. Especially excluded schedule is of scheduled areas and scheduled tribes. Administration of scheduled areas and scheduled tribes areas. Articles covered in this schedule is article number 244. Fifth schedule deals with the administration and control of the scheduled areas and scheduled tribes areas in India, especially excluded Assam, Meghalaya. All these provisions are mentioned under the schedule number 5. Schedule number 6 provide the provisions of administration of Assam, Mizoram, Tripura and Meghalaya. Administration of Assam, Meghalaya, Mizoram and Tripura. Articles covered in this schedule is 244 and 275. Assam, Meghalaya, Mizoram and Tripura, these states are very hilly areas. The states are fully covered by mountains, forests and valleys. So there are some hill districts in Assam, Meghalaya, Mizoram and Tripura. To administrate the hill districts, some special provisions are provided and some powers are granted to the governor of the states, and such related provisions are mentioned under the schedule number 6. Schedule number 7. Distribution of powers. Here we can see the 3 types of lists: union list, state list and concurrent list. 3 types of list: union list, state list and concurrent list. The articles covered in this is article number 246. So 7th schedule deals with the distribution of powers between state and center. 7th schedule
has the list of three types of list: union list, state list, and concurrent list. Union list now consisting of 98 items. The list of 98 items are seen in 7th schedule. 59 items are there in state list. All the 59 items are listed in 7th schedule. Concurrent list consisting 52 items. All the 52 items are listed in the 7th schedule. And the residuary powers are granted to the central government or vested in the name of central government. So the list of union, state and concurrent lists are seen in the 7th schedule. So 7th schedule deals with the distribution of powers. And 8th schedule deals with official languages. Official languages. This deals with articles number 344 and 351. 344 and 351. So when the constitution came into existence in 1950 January 26, 8th schedule consisting of only 14 official languages. Official language means the languages which are listed under the 8th schedule. Later 8 more languages are added to the 8th schedule. So right now there are 22 languages are listed in 8th schedule. So this 8th schedule consisting of the languages which are recognized by the Constitution of India. At the time of commencement of the Indian Constitution, 14 languages were recognized by the Constitution. Later, some more 8 languages are added to the 8th schedule. Right now, 22 languages are there in 8th schedule which are recognized by the Constitution of India. So there are 22 languages are recognized and they are listed in 8th schedule. Coming to the 9th, 10th, 11th and 12th, these 4 schedules are newly added after 1950. The 9th schedule deals with the anti-defection law. Anti-defection law. The 9th schedule deals with, it is nothing but acts that are and regulations of the state legislature dealing with land reforms, abolition of Zamindari system and other matters. 9th schedule is consisting of different types of acts that were enacted by the parliament and state legislature relating to the land reforms, abolition of Zamindari systems and reservation systems and whatever it could be. So in general, 9th schedule do not comes under judicial review. To make something act, to make a law, to make an order, to make an act, to not comes under the judicial review of Supreme Court and High Court, then the government has to plan to add such items in schedule number 9. If a subject matter is added to the 9th schedule, then that subject matter do not comes under the judicial review. That's why the reservation systems, the land reform systems, the abolition of Zamindar systems, such things which were enacted by the parliament or state assemblies were listed under the schedule number 9. This schedule deals with article number 354, articles number 31B. So in 9th schedule we can see the Land Reforms Acts, abolition of Zamindari system, reservation acts, and so on. If an act is added to the 9th schedule, what it means, in general, it do not come under the judicial review. But if the act which is added to the 9th schedule is violating the Constitution of India, is violating the basic structure of India, it must be reviewed by the Supreme Court or High Court. In general, if an act is not violating the basic structure of the Constitution, which is added to the 9th schedule, it may not be reviewed by the Supreme Court or High Court. If the act is violating the basic structure of the Supreme Court, violating the fundamental rights of the citizens, and it is added to the 9th schedule, it must be reviewed by the Supreme Court or High Court. In general nature, whatever the act is added to the 9th schedule do not come under judicial review. But if it violates the basic structure of Constitution, it must be reviewed by the Supreme Court or High Court. Okay. Coming to the next one, 10th schedule deals with anti-defection law. Anti-defection law deals with article number 102 and 199. What is anti-defection law? Anti-defection law means this is an act to control the party hooping or the party jumping of political systems. Nowadays, the political system is completely corrupted and the candidates are being changed from one party to another party. The candidates are jumping from one party to another party, and the other parties are also offered and attracted other party leaders by offering bribes, posts and money. These are called anti-political activities or anti-defection law. All these activities comes under anti-defection law. This was has to be stopped. For that, during the Rajiv Gandhi tenure, The 10th schedule is added to the Indian Constitution in 1985 by the 52nd Amendment Act, whereas the 9th schedule is added to the Indian Constitution in 1951 by the 1st Amendment Act. So later we will discuss about that. Coming to the next 11th schedule deals with the Panchayat Raj system, means Grama Panchayatis and their powers. It deals with articles number 243G. In 1992, P.V. Narasimha Rao government passed two types of constitutional amendment bills, 73rd Amendment Bill and 74th Amendment Bill, which gives the constitutional autonomy to the Grama Panchayatis and municipalities. So, and also the Grama Panchayatis are provided Grama Panchayatis are provided 29 powers by the 73rd Amendment Act, which was passed in the Parliament in 1992. It deals with Article 243G article. Coming to the 12th schedule, municipalities and their powers. Municipalities and their powers. As per the Constitutional Amendment Bill number 74, as per 74th Constitutional Amendment Act, municipalities are given 18 powers as per Article number 243W. That 18 powers are added to the 12th schedule under the Article number 243W. So these 4 schedules are added to the Indian Constitution later. So 9th schedule was added to the Indian Constitution in 1951 with the first Constitutional Amendment Act. 10th schedule is added in 1985 by the 52nd Amendment Act later. So 9th schedule was added to the Indian Constitution in 1951 with the first Constitutional Amendment Act. 10th schedule is added in 1985 by the 52nd Constitutional Amendment Act during Rajiv Gandhi period. This is during Jawaharlal Nehru period. 11th schedule is added to the Indian Constitution in 1992 by the 73rd Constitutional Amendment of Nehru period. By the 52nd Constitutional Amendment Act during Rajiv Gandhi period. This is during Jawaharlal Nehru period. 11th schedule is added to the Indian Constitution in 1992 by the 73rd Constitutional Amendment Act during P.V. Narasimha Rao period. The 12th schedule is added to the Indian Constitution in 1992 by the 74th Constitutional Amendment Act during P.V. Narasimha Rao. There is a chance to ask a question about the newly added schedules. 9th schedule, which deals with the Land Reform Acts, abolition of Zamindari Acts, Reservation System Acts, all these things are mentioned under the 9th schedule, is added in 1951 by the first Constitutional Amendment Act. So 10th schedule deals with the anti-defection law. It was added to the Indian Constitution in 1985 by 52nd Constitutional Amendment Act. 11th schedule deals with the 29 powers of Grama Panchayatis added in 1992 by the 73rd Constitutional Amendment Act. And 12th schedule deals with the 18 powers of the municipalities added to the Indian Constitution in 1992 by the 74th Constitutional Amendment Act. These are the 12 schedules of Indian Constitution. There is a big chance to ask questions in 4 areas. The first area is schedule number 2. Which of the following members and their salaries allowances are not mentioned under the second schedule? So then, if you want to answer this question, you should remember the 9 constitutional authorities. And also third schedule. Which of the following persons and their oaths, forms of oath are not mentioned under the third schedule? Then you should remember the oaths of these 9 persons. And coming to the 11th schedule and 12th schedule. How many powers are given to the Grama Panchayat as per 11th schedule? And how many powers are given to the municipalities as per 12th schedule? Okay, so practice more and more times on your rough papers and rough books and make a flow chart about the parts and schedules. Stick the flow charts of parts and schedules in your room and repeat and discuss with your students. Then you can easily remember the parts and schedules. This is the topic of parts and schedules of our Indian Constitution.